So, the Constitution gives you the point in time that he cannot preside. Now, this relates to him. There is no conflict of interest between him and third members under the 10th schedule. There is no conflict of interest. So, you can't apply the principle of conflict of interest to a proceeding under the 10th schedule where he is dealing with third parties. So, the whole premise of the argument is untenable.
There are 2 points here.
Yes.
That is, while is one aspect, and the other is that this talks only about himself. And
That's all my contention is. You can't make a constitutional assumption, because the whole argument has been on the premise that there's a constitutional assumption that he lacked mana fide. When Kyoto Holohan, just that paragraph of Kyoto, I'll give to your lordships, says you can't attribute to the speaker any such mana fide. That's why the provision of the 10th schedule was upheld. And just give your lordships just the page. I marked it on you. Just that paragraph I'll give to your lord.
You so easily vacillate from reposing such great confidence on the speaker on the one hand. Within a split second, you would again, I'm saying,
I agree.
In a split second, we know how the speakers have worked.
That's true. But precise. That is why
these two things which go from.
That is why the minority, according to me, was right. Because only you had to only strike down that part which gives speaker the authority. The rest of the 10th schedule would be maintained. The problem is with the speaker. So there is no defense of saying I am in majority. Your lordship is now taking a hard fact situation that the chief minister has lost confidence. Actually, he's only 50 people are out of 50, 40 are on the other side. I assume that against myself. Right? Now, they are still subject to disqualification. So what? That's why, as I said, these majorities can't be decided in the legislature. What they'll have to do is go to the party, take over the party, throw him out, and come to the house.
All that time is not there. By the time they go to the party, to the election commission.
That is why that is precisely my argument.
Therefore, Mr. Sibal, your argument, stretched to its logical conclusion would mean this, that even if a chief minister of a party completely loses the confidence of his own party in the house,
yes,
whether he has a confidence or not cannot be tested on the floor of the house.
It cannot be.
Which means that, according to, therefore, that a chief minister and a willing ally in a speaker,
the speaker will have to be with him. At least two people will have to be.
You can spot, because we are not dealing with a defection.
I understand.
Where you lose your own party, but then you continue because you have lost your own party.
I tell your lordships, then what will happen? It's very simple, then what will happen? Then what will happen is that under the schedule, the speaker will be removed without anything, without any other thing. The speaker will, a motion will be passed or whatever. The speaker may be removed and another speaker may be installed. But that's another issue. That situation has not arisen. At the moment, we are on what? From what date does the disqualification of the speaker commence?
Important question, Uddhav.
No, I think you've now made your submissions on the reference or the lack of reference.
I'm sorry.
The same thing, whether the reference needs.
Right, now just one other. There's a judgment of the UP Allahabad High Court, 1964 judgment which deals with this issue, luckily.
64?
And I tell your lordships what the judgment says. Then I give your lordships judgment.
Yeah.
But there the question arose that a chairman of the Legislative Council was sought to be removed. Now, at the time when the notice was given, he was there presiding. At the time when a motion was moved, he was still presiding. At the time when the leave was sought to be granted, he was presiding. A writ petition was filed that you could not have presided at the time when leave was granted to move the motion, right? Leave was refused. So, the question then arose and the court said, look, under the Constitution and the rules of the Assembly, he is not required to vacate his chair when leave is sought, because the resolution only comes up for consideration when a particular day is fixed for its consideration. Precisely what we've been arguing before your lordship. That's the judgment. So first question, if you seek a removal of the speaker, which has nothing to do with the 10th schedule, is he barred from dealing with disqualifications? It's no sense. We are arguing as if the only reason for removal is the 10th schedule. There are any number of reasons for which a speaker can be removed. So he'll be debarred to perform his adjudicatory function. Ex facie, a wrong proposition of law. Ex facie. In fact, 179 operates in an entirely different field. That's why the 10th schedule uses the word disqualification and 179 uses the word removal.
So if the Nabam principle is right, then once a notice is given of an intent to move a resolution to the speaker, not on the 10th schedule, but for any other reason, so long as the motion is pending.
That's right. The motion is pending. How does that? How will this argument? You will then have to make a distinction under 179 itself in interpreting 179 read with the 10th schedule.
No, but logically, Mr. Sibal, the argument of the principle in Nabam will extend irrespective of what the cause for the...
I agree, but that's what I'm arguing about.
That's right.
That's precisely what I'm arguing.
Because once the principle which Justice Mishra seems to have laid down is that once, and Justice Kher also, that once a notice for your removal is given, then, then there is a...
But there is a...
Except for one thing, I'll tell you what.
Yes.
In case of the 10th schedule, there is one additional factor. That when the speaker acts to disqualify somebody under the 10th schedule, he is affecting the majority in the electoral college which will decide upon his removal. Right?
Correct, but that's fine.
Suppose a speaker is supposed to be sought to be removed on the ground that, for whatever behavior in the house. They say that, you have not given the opposition sufficient time to speak, or you have not been even-handed. Just that hypothetical.
Correct.
In that case, there is no conflict of interest as such. That conflict of interest is taken care of by 181. Namely, that on that day when the motion comes up for consideration, you will not preside. You will have a right to
vote. That is motion to remove him.
Motion to remove him.
Absolutely right.
But there is no question of the speaker affecting by excluding certain members of the legislature.
I agree with that.
Because here what happens is the moment you rule on the disqualification, you are affecting the balance or composition of that body which will vote on.
I agree entirely with your lordship. Therefore, but 179 will still have to be interpreted in any situation. You can't ultimately you'll have to say that 179 in this context will not operate. The fundamental principle is keep an elected government that is already elected in place, keep it in place till such time as it can be thrown out. Of course, it should be thrown out, and that is not to be decided in the legislature. Kindly appreciate what is happening. This is another very interesting thing, and it's something that your lordship should think about. 5 people in Goa, say 2 of them or 3 of them are taken over by another party. The government falls, or 4 of them are taken. The argument is that under the principle of merger, since they have merged with another party, right? Now, what is the party? The Congress party still remains. Those 3 of only legislators have merged. The party still remains. It happens in the Rajasthan also. The BSP people have merged, but the BSP still remains. So what we are now doing, we are allowing the manipulation within the Legislative Assembly to topple governments through means that your lordships and I are aware of. And the purpose of the 10th schedule was not to allow that to happen. Not to allow that to happen. That was the purpose of the 10th schedule. Previously, it was 1/3 in paragraph 3. They said we removed the 1/3 because it was being used to topple governments. Now there is no paragraph 3. Now a bogey of majority is raised. If a minority can be bought, majority can also be bought. But to what end? To topple the government. And not to allow the speaker to decide the matter. Who can say, person sitting of one party in Guwahati, saying that he has not voluntarily given up membership of the party? He stares you in the face. He is passing resolutions from there that I remove you from chairmanship, I remove you from this office, I remove you from that office, I appoint myself. That's not supposed to be voluntarily giving up party. They are all arguing on the assumption that they are right when they say that there can be no disqualification for these acts. That's how they are arguing. And that the speaker, deputy speaker will malafidely say that they stand disqualified. You can't make a constitutional assumption like that. That's the assumption they are making. See what the speaker is doing. He only gave us 2 days notice. Why did he give you 2 days notice? Because the facts stare him in the face. That's the reason for the 2-day notice. Now, your lordships, when dealing with the merits of the matter, will decide whether that was enough, not enough in the facts of the case, but that's on merits. But the issues are far larger. And if this is allowed, it can happen anywhere, and it will happen. It has happened. This is not the first time. Now, having said that, kindly come to the 10th schedule for a minute. Even when the motion is in the House, he may not be willing to move it. So there can be no injunction for him to continue with the 10th schedule and the proceedings. Because the resolution, let me tell you, I have some experience in Parliament, let me tell you what happens. Whereas what happens is that whenever a resolution...
But according to you, there can't be any injunction at all, irrespective of the stage of the motion.
Yes, yes, because that is to win. This third...
According to you, even if it is admitted, there is no bar on the
No.
Even during the 7 days.
Yes. Well, I tell you, Lordship, why? Well, the 10th schedule deals with strangers. The motion deals with him. The 10th schedule deals with third parties. The motion deals with him, so he cannot preside on that particular day when it's under consideration. Well, what has got to do with third parties? Now, these issues were never discussed in Nabam. There is no concept of majority, minority under the 10th schedule anymore. The only concept is of merger.
Merger, that's the only thing.
So to say that the majority, we are 40, is no defense under the 10th schedule.
But this is not a case of merger also, as
It's
saying.
It's not their case of merger. So to say, I've been hearing this refrain that we are 40, they are, it makes no difference. That is why para 3 was removed. These are very serious issues. You can't apply Nabam Rebia in this fashion. And therefore, Mullahs, my Lord put it to me, if you have lost the plot, Mullahs, we have not lost the plot. Because the 10th schedule itself allows me. There is no defense available. Which is why they don't want this to go on. Which is why, Mullahs, they are saying it is academic. Don't deal with it. Our speaker will decide. Now we have a new speaker. And now we can't remove him because they have the majority now. So even if we give a notice, we can't remove him because they've toppled the government. See the serious consequences of this. And what moral principles are we talking about, Mullahs? These are not conscientious objectors, Mullahs, like in Soviet citizen wars, Mullahs, in Russia. These are conscientious defectors, where they lay their conscience on a platter and depends on who bids the highest. Let's not make these moral principles in this. We know what happens. So, please, I beg of you, this is not about today. This is about tomorrow. Don't board the issue, Mullahs, and say it doesn't arise. It will arise time and again. Elected governments will be toppled. And no democracy in the world allows this to happen. Why do you allow the party to use the 10th schedule? In fact, the process must be, this is my Mullahs, and when I argue the merits, the process must be that an elected government must continue till the disqualification petitions are decided. If they are disqualified, that's the end of the matter. Your Lordships is there to protect them. If they are not disqualified, the elected government will go. But do not allow the 10th schedule to topple an elected government. And do not interpret 179, 181, the moral principles that Justice Mishra talked about, to allow this to happen. It's far too serious. It's not just a narrow interpretation.
Mr. Sibal, ultimately, equally, what your submission is, therefore, give free rein to the speaker.
No,
to the speaker.
No, Mullahs.
Without imposing any restraint.
No. Please don't do that. And I tell your Lordship the solution. What's the free rein, Mullahs? He cannot deal with a disqualification unless there is a disqualification petition. He has no right to suo motu deal with it. Mullahs, the disqualification petition will come under 21A or 21B. 21A, if he violates the whip, Mullahs, what's the free run for the speaker there? In this, what happened? On the 3rd of July, at the time of the election of the speaker, the whip in the house was Sunil Prabhu. He had not been changed. He directed that the Shiv Sena candidate should be voted for by these defectors. They voted against. They elected the BJP candidate, not the Shiv Sena candidate.
Interestingly, both your argument and the argument of the other side, which espouses the Nabam principle, rely on the same principle, namely the importance of the speaker. They say, because of the importance of the position of the speaker, it's important that you must exclude any possibility of conflict of interest.
No, where is the conflict?
You say that in view of the importance of the position of the speaker, allow him to decide.
No, I say don't allow an elected government to be toppled in this fashion. Mullahs, no. Don't allow the verdict of the people to be toppled or an elected government to be toppled in this fashion. That's the fundamental principle. A government stands elected till it is removed. And it cannot be removed through the machinations under the 10th schedule. That's my contention. Mullahs, forget about the speaker or no. This is the fundamental principle of democracy. And if you have violated the 10th schedule, allow the speaker to decide. Mullahs, he can't decide contrary. If there's a whip, Mullahs, that has been issued and somebody votes against the whip, what leeway does the speaker have? You are giving a leeway to the other side, disabling him, toppling the government, and then not deciding the matter. I remember, Mullahs, when the Rajasthan matter came up on this court, Justice Arun Mishra They, on a daily basis, used to monitor the disqualification proceeding. On a daily basis. When it came to Rajasthan. When it came to Goa, for 2.5 years, we kept on telling the Chief Justice, please have the matter heard, please have the matter heard. Where do we go? These are all nice principles of law, but you have to have a functioning, working democracy. This is why it's far too serious, Mother. The fundamental principle is keep an elected government that is already elected in place, keep it in place till such time as it can be thrown out. Of course, it should be thrown out, Mother.